Is this everyone?
5:33, we'll call the meeting to order. If you're ready. I will go ahead and do roll call. Commissioner Ramos,
Present.
Commissioner Bloomer,
Here.
Commissioner Figueroa,
Here.
and Commissioner Esteban.
Here.
Okay, and Tom Dolan has an excused absence. He is in California babysitting his grandchildren. We can move to the minutes to approve the August 20th, 2024 special meeting. Did everybody get a chance to look those over? It's pretty cut and dry.
Make a motion to approve.
I will second that. Motion has been made by Commissioner Gary, seconded by Moore. All in favor say aye.
Aye.
I vote aye as well. All those who oppose. Motion has passed to approve the minutes for August 20th, 2024 special meeting. Down to number 2 on the active agenda, open government training. Joseph, we'll hand that over to you.
All right, well, thanks everyone. So we discussed a little bit at the last meeting about doing some open public meetings act training and some questions about that. So today we are going to go through a few of the lessons that are provided on the Attorney General's website. We'll start with the first, which is a PowerPoint, and then there are 2 videos that follow. There are 2 additional lessons on there as well, but they're more geared toward the public records officer. But it's still interesting information if you choose to go through that, and I can provide the website URL so you can check that out at your leisure. I'll move this so it's out of the way, and yeah, we'll get started. So again, this is provided by the State Attorney General's office. It provides some history of open public meetings. Obviously our country was founded on a level of transparency and openness to that the people have to their government, and that has been passed down from the federal level and has been codified at various times at the Washington State Supreme Court. They're often referred to as transparency or sunshine laws, really just trying to build public confidence in the government. There's 2 primary statutes in the RCWs. 4256 is the Public Records Act, and 4230 is the Open Public Meetings Act. And the following videos will mostly focus on the Open Public Meetings Act. Public records, basically everything that the government does creates a record, which are all accessible and producible to the public. And those records being available for public request and consumption is a very important part of being a transparent and open government. That follows to open public meetings. Every meeting, such as the meetings that the Planning Commission holds, Council holds, other subcommittees or commissions, the public has a right to attend and receive information from those meetings. Some more history on this. The Public Records Act was initially passed in Washington in 1972, requiring all agencies to maintain and distribute those public records, and the Open Public Meetings Act was passed in 1971, and obviously there have been many updates to that throughout the years. Again, open is going to be a big topic of this. So the keeping records and meetings available, providing that information in a timely manner, and making sure that the public is aware that these things are all accessible to them is very important. Public Records Act applies to writings containing information relating to the conduct of government or the performance of any government or proprietary function, basically used for government. So emails and correspondence between and to the planning commission is subject to the Open Public Records Act. So people in the community could request, for example, all correspondence between August 1st and August 30th between the planning commission, and those emails would be accessible and available. There's certain things that can be redacted from those, but there's a whole laundry list of requirements for what can and cannot be redacted, and that's really a case-by-case basis. And then again, open public meetings is applicable to the planning commission as a seated advisory board to the council, who makes recommendations on policy and on project-specific and quasi-judicial actions. As I mentioned, there's certain things that can be withheld from public records. Those are on a case-by-case basis. And then there are certain things in the Open Public Meetings Act that a council can go into executive session. There's also certain actions, such as some of the applications that planning commission that they'll look at when you provide a recommendation to the council, they will hear it in a closed record public meeting. That doesn't mean that people can't speak on it, but it just means that no new information can be presented. Enforcement of the Public Records Act can get to the courts if there are perceived conflicts or disagreements with what was requested versus what was provided. And there's I don't even want to speculate as to the number of court cases the state processes on this throughout the years. But it can be really expensive for a city or other municipality to, if they're found to have withheld records, that can be very costly. Similarly, open public meetings violations can be very costly as well. Really talking about risk management, that's one of the main functions of these trainings, is to make sure that commissioners, councils, elected officials are aware of the requirements for open public records and open public meetings. These things are updated frequently, and so these trainings, a lot of municipalities has an annual requirement or every other year requirement, so that people can get caught up on recent changes in state law and best practices. Again, this information is provided by the Attorney General's office, and in addition to these trainings, they have several pages on their website that go into far greater detail on all the different intricacies of open public meetings and record retention. So that's a real high overview of just both public meetings and the public records portions. So now we'll sit back and relax and watch this Public Records Act training video.
Hi, I'm Bob Ferguson, your Attorney General. With me in this video is the Open Government Assistant Attorney General, Nancy Creer. This training video provides a basic overview of our Public Records Act for both records requesters and state and local agencies. It's intended to provide greater understanding of the legal requirements around the Act. The Public Records Act is a law created by an initiative vote of the people in 1972, which provides the public access to the records of government agencies. It received 72% of the vote. The purpose of the Act is to provide the public full access to information concerning the conduct of government, mindful of individuals' privacy rights, and fulfill the desire for the efficient administration of government. The law is based on the principle that open government is essential to a free society. All state and local agencies must comply with the Public Records Act. All public records must be disclosed unless a law exempts records or information. There are well over several hundred exemptions. Some of those exemptions are listed in the Act, but many exist in other state and federal laws. The Act is a broad mandate interpreted in favor of disclosure, and its exemptions are narrowly construed.
This training presentation is based on the Public Records Act and the Attorney General's Advisory Model Rules. The rules are online at the Attorney General's website at www.atg.wa.gov. They provide examples of steps to comply with the Public Records Act. An agency may adopt any part of the model rules into its own rules. Local agencies should consult the model rules when establishing local Public Records Act ordinances. The model rules provide comments that are useful for interpreting the Public Records Act and for training agency personnel. The model rules are non-binding, but they are based on extensive outreach, court decisions, and have been cited favorably in some court cases. This training video was prepared in the fall of 2017. The model rules were being updated in 2017. The legislature also amended the Public Records Act in 2017, and the legislature can amend it again in the future. The courts can also interpret the Act. Consequently, and as a reminder, there may be developments in the law after this video is prepared. Several updates on the law are often posted in materials on the Attorney General's office website on the Open Government Training page. A PowerPoint on that page also provides training on the Public Records Act. This training video contains 16 short segments where we will review history, purpose, and intent of the Public Records Act, scope of the PRA, general obligations of an agency, what is a public record, requests for records, initial agency responses, reasonable estimates, adequate searches, disclosure, electronic records, managing broad requests, exemptions and withholding, fees, other records provisions, liability, and finally, additional resources. You have just heard from the Attorney General about the history, purpose, and intent of the Act. The Act regulates the disclosure of public records. The Act requires disclosure of public records unless a law permits withholding of a record or part of a record. The Act has many components, and compliance requires training. Training can be the difference between a satisfied requester and expensive litigation. The Act applies to both state and local agencies. A state agency includes every state office, department, division, bureau, board, and commission. A local agency includes every county, city, town, municipal corporation, special purpose district, and other forms of local government. In some cases, an entity which is not an agency can still be subject to the Act when it is the functional equivalent of an agency. This determination depends on whether it performs a government function, receives government funding, the extent of government involvement or regulation, and whether the entity was created by government. Courts are not subject to the Act. Agencies must appoint a public records officer responsible for being a point of contact for the public and for overseeing compliance. The name and contact information of the public records officer should be published with information on how to submit requests for records. The public records officer must have received training on the Act within 90 days of assuming his or her duties. Agencies must also publish information on the agency organization, rules, and procedures, and an index of specific categories of records. Agencies are required to adopt reasonable rules to provide full public access to public records, to protect public records from damage or disorganization, to prevent excessive interference with other essential functions of the agency, and to provide the fullest assistance to inquirers. Agencies may wish to consult with their attorneys when developing their rules and procedures. A public record is any writing relating to the conduct of government which is prepared, owned, used, or retained by any state or local agency, regardless of physical form or characteristics. It could be an email, text message, paper, letter, or memo, an audio or video recording, a picture, image, map, or any recording of information or data compilation from which information may be obtained or translated. A public record is not just what an agency creates, but includes documents created by citizens or private companies that are used or received by a government for a governmental purpose. A public record may also include documents not possessed by the agency, but which were used by the agency. For example, the courts have described that work documents on the personal computer, personal cell phone, or personal email account of an agency employee or official are subject to a request under the Public Records Act. Records of certain volunteers are excluded from the definition of public record. Records are excluded when they are not otherwise required to be retained and are held by volunteers who do not serve in an administrative capacity, have not been appointed by the agency to an agency board, commission, or internship, and do not have a supervisory role or delegated agency authority. Any person wishing to inspect or copy public records of an agency should submit the request to the agency, preferably in writing, using the agency's request form. The Public Records Act doesn't prescribe any official format for a valid request, so an agency must honor valid requests for identifiable records regardless of the format of the request. While using an agency's form is not required, it is typically the most efficient way to submit a request. A requester who chooses not to use an agency form must give the agency fair notice that he or she is submitting a request for public records. Agencies are required to honor requests received in person during an agency's normal office hours or by email. If an agency has adopted reasonable rules on how requests should be submitted, the agency may rely on those rules. The agency should be helpful to the requester in explaining how a request should be submitted and to whom. Records shall be available for inspection and copying upon request for identifiable records. So requesters should give a reasonable description of the records, enabling the agency to search for potentially responsive records. A request for all or substantially all of an agency's records is not a proper request for identifiable records. A request regarding a particular topic or containing a particular keyword or name shall not be considered a request for all of an agency's records. A request for information is not the same as a request for public records. The Public Records Act does not apply to requests for information. There is no duty to create a record that does not exist in order to fulfill a request for records or information. However, requests for information are at times easier to fulfill. Fulfilling a request for information may avert a large public records request. An agency must promptly respond to public records requests. Within 5 business days of receiving a request, an agency must respond. An initial response may be any one of the following: acknowledging receipt of the request and providing a reasonable estimate to respond, or fulfilling the request, or providing an internet address and link to the records on the agency's website, or seeking clarification while also, to the greatest extent possible, providing an estimate of time for further response if the request is not clarified, or denying the request with an accompanying written statement of the specific reasons. Reasonably clear requests for identifiable records may require no clarification. However, some requests are unclear. Seeking clarification permits the agency to identify responsive records, which in turn will aid in determining the scope of the request. Clarifying a request provides the fullest assistance to the requester so that the requester receives and pays for only those copies that are desired. Clarification may also result in prompt disclosure by identifying only those records desired. An agency should not seek clarification if the request is for identifiable records and is reasonably clear. If the entire response is unclear and the requester fails to respond to the agency's request for clarification, the agency need not respond to it. However, the agency must respond to those portions of a request that are clear. An agency may deny a bot request, which is a request that was automatically generated by a computer program or script when it is one of multiple requests from the requester received within a 24-hour period. The agency must establish that responding to the bot request would cause excessive interference with other essential agency functions. A requester is typically not required to provide the reason for a request unless a law necessitates additional information from the requester. Agencies and requesters are encouraged to promptly communicate with each other if there are issues regarding a request. An agency's initial response to a public records request must provide a reasonable estimate for the time to respond when more time is needed. A reasonable estimate should account for many factors, including the time to have the requester clarify the request if needed, as well as time to assemble and review the records, provide notice to affected persons or agencies if needed, to redact exempt information, and to create a withholding or exemption log. An agency should not use the same estimate for every request. Rather, each reasonable estimate should be based on factors such as the complexity of the request, other pending requests, agency resources, and other agency essential functions. It's a good practice for an agency to briefly explain to the requester the basis for the estimate in the initial response. Extending the estimate is appropriate when circumstances have changed or additional information has come to light. Agencies are encouraged to briefly explain the need to revise an estimate. An agency bears the burden of showing that its search was adequate. Consequently, agencies should be able to document how a search was conducted and, for example, what search terms it used, as well as the location searched. An adequate search depends on the facts of each request, but it is one that is reasonably calculated to uncover all responsive documents in whatever form, paper or electronic. An agency must make more than a perfunctory search and follow obvious leads as they are uncovered. The search should not be limited to one or more locations if there are additional places where responsive records are likely to be found. If responsive public records are likely to be found on or in an agency employee's or official's personal device or account, the employee or official must search those devices and accounts for responsive records. It is possible to conduct an adequate search and still not locate a responsive document. However, if a responsive record is not located and or if challenged in court, the agency will have to prove its search was adequate. An agency must make records available during its customary office hours for a minimum of 30 hours per week. Public records are presumed to be open for inspection and copying unless a specific law exempts the record or information from disclosure. Agencies can deliver copies of records to a requester in a number of ways, such as providing links to the records that are on the agency's website, providing paper copies of paper records or scanned copies of paper records by mail or making them available for pickup, or providing electronic records by various methods. You may recall that with respect to what is a public record, the Public Records Act does not distinguish between paper and electronic records. Most agencies create records in an electronic format. A copy of an electronic record should be produced in the requested electronic format if reasonably feasible. Translating a record into an alternative electronic format at the request of the requester, or scanning a paper record, is not creating a new record. Metadata is information embedded in a document that provides detail about the document's characteristics. This may include information such as when the document was created, edited, recipients, and so forth. Non-exempt metadata must be disclosed when expressly requested. When agencies obtain new technologies, they should consider not only the agency's business operation needs, but also records retention and disclosure requirements. Examples of such technologies are portals through which records can be requested and delivered, electronic redaction tools, or retention software, just to name a few. In addition, agencies can look at whether they could make use of their current technology more robust. The legislature encourages agencies to make public records widely available electronically, particularly commonly requested records. For example, an agency could make commonly requested records available on its website. Then, as noted earlier, an agency could fulfill its obligation to provide access to a public record by providing a requester with a link to a specific agency webpage containing the electronic copy of the requested record. For requesters without access to the internet, an agency could provide a computer terminal at its office. Agencies should develop policies addressing technology concerns, such as if and when agency employees may use personal devices for public agency uses, and what responsibilities and requirements therefore attach to the employee. An agency may receive a broad request that asks for any and all records related to a topic. Agencies may not deny a request solely because it is overly broad. As noted, a request for all or substantially all of an agency's records is not a valid request. But a request for all records regarding a particular topic or containing a particular keyword or name is not a request for all of an agency's records. After an initial search shows there are potentially hundreds or thousands of different types of responsive or potentially responsive records, a public records officer should contact the requester to explain the estimated total number of records that would need to be searched, or provide other information describing the anticipated scope of the search. Then the agency could seek clarification to ask if the requester wants all of the different types of responsive records and is willing to pay for all the copies, or instead, if the requester is seeking only some of the records. Good communication can assist both the agency and the requester. A broad request will usually result in a longer estimate of time for disclosure, as well as producing records in batches or installments. When seeking clarification, to the greatest extent possible, the agency must provide a reasonable estimate of time the agency will require to respond to the request if it is not clarified. In many instances, a requester will narrow the scope of the request to enable the agency to provide disclosure more promptly and less expensively. An agency may manage broad requests in a couple ways. An agency may require a deposit in an amount not to exceed 10% of the estimated cost of providing copies for a request. If an agency makes copies in response to a request available on a partial or installment basis, the agency may charge for each part of the request as it is provided. If an installment of a records request is not claimed or reviewed, the agency is not obligated to fulfill the balance of the request. Finally, use of electronic technologies to search, review, redact, and disclose public records can reduce overall costs of compliance for agencies. Agency responses denying in whole or in part inspection or copy of any public record shall include a statement of the specific exemption authorizing the withholding of the record and a brief explanation of how the exemption applies. Exemptions exist throughout the Public Records Act and other state and federal laws. Common exemptions include information such as personal information in files maintained for agency employees if private, pending investigative files compiled by law enforcement or agencies with authority to discipline members of a profession, the non-disclosure of which is essential to effective law enforcement or for the protection of any person's right to privacy, educational records of students in public schools, attorney-client privilege information or work product related to litigation, or protected healthcare information. There is no statute providing a general privacy exemption. If privacy is an express element of a specific exemption,
Let's try and move that out of the way.
Some of those exemptions are listed in the Act, but many exist in other state and federal laws. The Act is a broad mandate.
So
requester is with a withholding index, often called an exemption log. The information provided as part of the log should include a description of the type of record or part of record denied. The description should include identifying information from the document. For example, whether the document is a letter or email, the date the document was created or other relevant date, the total number of pages, and the sender and recipients. The exemption log must also include the statutory authority making the information exempt and a brief explanation of how the exemption applies. Some of this information will be evident on the face of the document where redactions have been made to only part of the document. An exemption log, the written explanation, also may be provided in different formats. For example, maybe handwritten or compiled in a spreadsheet or chart, or in a letter, or redactions are marked on the records with exemption codes, and the requester is given the key to the codes. The format of the exemption log or exemptions is not relevant so long as the required information is provided. Any person may inspect non-exempt public records for free. An agency may not charge for the time of staff to search, review, or redact public records when preparing them for inspection. If a requester wants copies of records, an agency has options to charge for copies. It can charge actual costs, or it can charge default fees listed in the Public Records Act, or it can charge an alternative up to $2 fee for an entire request. Some other provisions may be relevant too. In order to charge actual costs, an agency must make available for public inspection and copying a statement of the actual per page or other costs and how it determined actual costs. An agency may adopt its statement of actual costs only after providing notice and a public hearing. When calculating fees, the agency must use the most reasonable, cost-efficient method available to the agency. Staff time to copy and deliver the requested public records may be included in an agency's costs, but an agency may not include staff salaries, benefits, or other general administrative or overhead charges unless those costs are directly related to the actual cost of copying the public records. An example of when an agency may want to charge for the actual cost of staff time is where an agency scans paper records and copies them into an electronic format. The charges should be reasonable and related to the wage of the person likely to be repeatedly assigned to this task. If an agency does not have staff available to make copies, for non-exempt records, an agency may send a scanning or copying project to an outside vendor and pass on the actual cost to the requester. Electronic copy costs may include the actual cost of the electronic production or file transfer of the record, the use of any cloud-based data storage processing service, and the cost of transmitting electronic records, including the use of a physical media device. A second method to charge copy costs is for an agency to choose to use a statutory default fee schedule provided in the Act. In that case, an agency need not calculate actual costs if it has rules or regulations declaring the reasons doing so would be unduly burdensome. The statutory default fee schedule lists, for example, per page costs for paper records, scanned records, and costs for electronic records. As yet another alternative, an agency can assess an up to $2 flat fee for an entire request when certain conditions are met. The Act includes other fee provisions. For example, an agency cannot charge for access to or downloading of records it routinely posts on its website prior to the receipt of a request, unless the requester has specifically asked that the agency provide records through other means. An agency may impose the actual cost of a customized service charge when the request would require the use of IT expertise to prepare data compilations, or when such customized access services are not used by the agency for other business purposes. The agency must notify the requester and take other steps if it chooses to do a customized service. An agency can require an advance 10% deposit before making copies. An agency may enter into a contract, memorandum of understanding, or other agreement with a requester for an alternative fee arrangement or in response to an extensive or frequently occurring request. An agency may choose to waive any charge pursuant to agency rules and regulations. Upon request, an agency must provide a summary of the applicable charges before making copies. The requester then may choose to revise the request to reduce the number of copies and the cost. In sum, the Public Records Act provides an agency several options for assessing charges for copies. The choices selected may vary from agency to agency. Under a different law, the records retention laws at RCW 40.14, agencies must maintain a log of public records requests, including for each request, the identity of the requester if provided, date of receipt, text of request, description of records produced, description of records redacted or withheld and the reasons for doing so, and the date of final disposition. With respect to the identity of the requester, it is possible an agency received only an email address from the requester, and if so, that address would be included in the log. The logs must be retained per the agency's records retention schedule and are a public record. The records retention law also provides that agencies spending at least $100,000 to fulfill requests during the prior fiscal year must report 17 data points about their PRA requests to the Joint Legislative Audit and Review Committee. Under the Public Records Act, any person having been denied an opportunity to inspect or copy a public record may seek further review in the agency. The person may also file a lawsuit to enforce his or her right to access public records. A requester can also file a lawsuit if he or she believes that an agency has not made a reasonable estimate of the time or of the charges to provide public records. Such a lawsuit is to be filed in a court within 1 year of an agency's final definitive response to a request, such as a final claim of exemption or the last production of public records on an installment basis. The agency has the burden of proof to demonstrate that public records were lawfully denied or its estimates were reasonable. If it does not make this showing, an agency will pay the requester's reasonable attorney's fees and costs and may pay potential penalties for denying records in violation of the Public Records Act. A court will consider mitigating and aggravating factors in determining a penalty amount. Lawsuits for public records can be extremely time-consuming and expensive for agencies. Understanding and correctly applying the law is a good risk management tool for state and local government. In rare cases, individual employees may also be civilly or criminally liable under other laws. State agency employees and state officers are subject to the Ethics in Public Service Act. It is a violation of that state ethics law for a state employee or officer to intentionally conceal a public record required to be released under the Public Records Act. State agency employees and officers may be fined up to $5,000 per violation of the state ethics law. It's also a crime for any agency officer to willfully mutilate, destroy, conceal, erase, obliterate, or falsify any record of that agency's office, except where the law expressly authorizes the non-disclosure or destruction of records. The crime is punishable by imprisonment of up to 10 years or a fine of up to $5,000 or both.
Thank you for participating in the Attorney General's Open Government Training. For more information, there are available resources for agencies to receive training and technical assistance for compliance with the Public Records Act. An employee should first consult with its agency's public records officer for routine assistance or training. Additional resources are listed on this website. The Assistant Attorney General for Open Government is also available to provide information about the Public Records Act. Thanks again for watching.
All right, we got one more video. This one's not as long. This is the portion. Try not to move the mouse.
Hello, I'm Assistant Attorney General Morgan Dameron. This training provides an overview of the Open Public Meetings Act. It's intended for both the public and public agencies. Our purpose in this training is to provide a greater understanding of the legal requirements of the Open Public Meetings Act. The Act was passed in 1971, a time of a nationwide effort to make government affairs more accessible and more responsive. The purpose of the Act is to provide the public access to information concerning the conduct of state and local government. The law is based on the principle that open government is essential to our free society. The Open Public Meetings Act gives the people of Washington State the opportunity to witness the deliberations and decisions of government. More recently, that's included an opportunity to provide public comment as part of that process. Multi-member governing bodies of state and local agencies such as school boards, city and county councils, and the state commissions must comply with the Open Public Meetings Act. The law states that it is intended that the actions of these governing bodies be taken openly and that their deliberations be conducted in an open manner. Meetings subject to the Act must be open to the public, gavel to gavel, unless the law permits a meeting or part of that meeting to be closed. Thank you for watching, and I hope you find this training informative. This training's purpose is to increase your knowledge of the Open Public Meetings Act. The OPMA is in Chapter 4230 of the RCWs, and this training incorporates updates from the 2022 legislative session. This training video contains 15 short segments. We just discussed Section 1, the history, and Section 2, the purpose of the Act. The remaining segments will review the scope of the OPMA, what is a governing body, what is a meeting, what is action and final action, travel and gathering, regular meetings, special meetings, remote meetings. We'll also talk about executive sessions, public attendance and comment, minutes, liability, as well as other laws, and provide some additional resources to assist you. The Act has several clear requirements, and compliance with them is improved with training. Training can mean the difference between meeting your agency's OPMA obligations and expensive litigation. The Act applies to governing bodies of multi-member public agencies, both state and local. At the state level, public agency includes state boards, commissions, committees, departments, educational institutions, or other state agencies, which is created by or pursuant to statute. Public agency does not include the courts or the legislature. For local governments, public agency includes any county, city, school district, special purpose district, or other municipal corporation or political subdivision of the state of Washington. Examples of these include city councils, county councils, school boards, and fire district boards. Public agency may also include a sub-agency of a public agency, which is created by or pursuant to statute, ordinance, or other legislative act. A good example of these includes planning commissions, library or park boards, or commissions. A final group is any policy group whose membership includes representatives of publicly owned utilities formed or pursuant to Washington laws when meeting together or as or on behalf of participants who have contracted for the output of generating plants being planned or built by an agency operating them. In some cases, an entity which is not an agency may still be subject to the OPMA when it is the functional equivalent of a public agency. This determination depends on whether it performs a governmental function, receives governmental funding, the extent of governmental involvement or regulation, and whether the entity was created by government. Some activities of public agencies are not subject to the OPMA. They include certain licensing and permitting activities, quasi-judicial matters, matters governed by the Washington State Administrative Procedures Act, and certain collective bargaining activities. All meetings of the governing body of a public agency shall be open, and the public and all persons shall be permitted to attend any meeting of the governing body of the public agency, except as otherwise provided in the OPMA, such as during a declared emergency. A governing body is defined as a multi-member board, commission, committee, council, or other policy or rulemaking body of a public agency, or any committee thereof, when the committee acts on behalf of the governing body, conducts hearings, takes testimony, or public comment. Agencies governed by an individual, such as a single director, are not subject to the OPMA. Meeting means meetings at which action is taken. Physical presence of the members is not required. A meeting can occur by phone or in some cases by email. I will talk more about email exchanges later in this training. A meeting does not need to be titled meeting. The OPMA also applies to retreats, workshops, and study sessions. In order for there to be a meeting, there must be a quorum of the governing body. A meeting does not occur if there is no quorum. We've talked about the fact that the OPMA applies to a governing body at a meeting. In order to qualify as a meeting, the governing body must take action. Action means the transaction of the official business of a public agency by a governing body, including but not limited to receipt of public testimony, deliberations, discussions, considerations, reviews, evaluations, and final action. A subset of action is final action. Final action means a collective positive or negative decision or any actual vote by a majority of the members of a governing body when sitting as a body or an entity upon a motion, proposal, resolution, order, or ordinance. Final actions must occur in public. Secret ballots are not allowed. A majority of the members of a governing body may travel together or gather for purposes other than regular meetings or special meetings, so long as no action is taken. And remember, action includes discussion of agency business. This means a quorum of members can travel to a meeting together, or they can gather at a public or private event, such as a festival or social function, so long as they do not collectively discuss agency business or matters. In the next segments, we are going to talk about the types of meetings where a governing body may meet. The first is regular meetings. Regular meetings are recurring meetings held in accordance with a periodic schedule by ordinance, resolution, bylaws, or other rule. State agencies file these notices of regular meetings each year with the Office of the Code Reviser. Regular meeting agendas are to be posted online on an agency's website 24 hours in advance. A special purpose district or city or town is not required to post an agenda online if the agency has an aggregate valuation of property in the taxation district of less than 400 million, a population of less than 3,000, and provides confirmation to the state auditor when filing its annual report that the cost of posting notices to a website would exceed 0.1% of the agency's budgets. These provisions exempting very small agencies changed in 2022. Certain notice requirements are required for special meetings. These include written notice 24 hours in advance of the meeting, provided to members of the governing body unless waived. The notice must be provided to local newspapers, radio, and TV stations that have a request on file with the agency. The notice must also be posted on the agency's website if it has a website. There is an exception for very small agencies, agencies with no FTEs, or with no one whose job responsibilities, either by job description or by contract, with the responsibility to maintain or update the agency's website. The notice must be prominently displayed at the main entrance site and the meeting site unless the meeting is being held as a remote meeting or one where some or all members of the public are limited due to a declared emergency. The remote meeting provisions are new, and we'll be addressing those in just a moment. The notice must specify the time, place, and business to be transacted. Unlike regular meetings, where the agenda may be changed and final action taken on a matter which was added to the agenda, under special meetings provisions, the governing body is prohibited from taking final action on any issue not on the original notice. There is an exception to the notice requirement for emergency special meetings. Those are meetings involving injury or damage to persons or property, or the likelihood of injury or damage, where time requirements make notice impractical and increase the likelihood of injury or damage. New in the OPMA through the 2022 amendments are provisions addressing a governing body holding remote meetings. After the declaration of emergency by a local or state government or agency or by the federal government, and the agency determines that it cannot hold a meeting of the governing body with members of the public in attendance with reasonable safety, the agency may either hold an all-remote meeting without a physical location or hold a meeting with the governing body present but some or all of the public excluded. In either of these instances, the agency must provide an option for the public to listen telephonically or by using a readily available alternate means in real time, such as an available television cable broadcast or the internet. Any option selected may not require any additional costs to access the program. If the agency does not provide an option, the agency is prohibited from taking action except for an executive session as authorized under the OPMA. If your agency is holding an all-remote meeting with some or all of the public excluded, The notice of the meeting must include instructions on how the public may listen live to the meeting. An agency that held some of its regular meetings remotely prior to March 1st of 2020 may continue to do so with no declared emergency, so long as the agency provides an option for the public to listen as required for emergency remote meetings. Up to now, we've been talking about all the requirements to ensure openness and transparency. Under the OPMA, there are enumerated instances where the governing body may convene outside of the public's view in executive session, or if the governing body is discussing matters not subject to the OPMA. An executive session may occur as part of a regular or special meeting. The grounds for holding an executive session are limited to the purposes listed in the OPMA and are narrowly construed. The purpose of the executive session and the time it will end must be publicly announced before excluding the public, and the time can be extended by further announcement. Examples of purposes include certain real estate transaction discussions, reviewing negotiations on publicly bid contracts, evaluating the qualifications of an applicant for public employment, and meeting with legal counsel regarding enforcement actions, litigation, or potential litigation. The OPMA provides a list of authorized executive session purposes at RCW 4230-110. An agency must carefully follow the law when meeting in an executive session. For example, when meeting in an executive session under the OPMA to discuss agency enforcement actions, litigation, or potential litigation, there are 3 requirements. First, legal counsel representing the agency must be present. Second, the purpose is to discuss an agency enforcement action, litigation, or potential litigation to which the agency, governing body, or a member acting in official capacity is a party or is likely to become a party. And finally, public knowledge regarding the discussion is likely to result in an adverse legal or financial consequence to the agency. Remember, an agency can discuss only those matters in an executive session under the OPMA that it has told the public it would discuss. The members cannot talk about other topics in that executive session. In addition to an executive session, a public agency can have a closed meeting to discuss matters not subject to the OPMA, such as deliberating on a quasi-judicial matter or collective bargaining. Other laws may provide additional procedures or authority for particular meetings or hearings to be closed to the public. There may be additional laws for particular agencies as well. As we discussed, all meetings of the governing body of a public agency shall be open and public, and all persons shall be permitted to attend any meeting of the governing body of a public agency, except as otherwise provided in the OPMA. An agency also cannot place conditions on attendance, such as requiring persons to register their names or fill out a questionnaire before attending. This provision does not prohibit any generally applicable condition determined by the governing body to be reasonably necessary to protect public health or safety, or to protect against interruption of the meeting, including a meeting at which the physical attendance by some or all members of the public is limited due to a declared emergency. As noted, email or phone call discussions amongst members of the governing body can be a meeting under the OPMA. But the purpose of the OPMA is to permit the public to attend and observe agency meetings. So when the public is unable to attend email or phone call discussions that are meetings under the OPMA, the act has been violated. Recent amendments to the OPMA make it clear members of a governing body can participate in meetings remotely with no declared emergency. However, public attendance must be maintained. In doing so, it is generally agreed that public notice procedures must be satisfied, and the agency has to set up a process for the public to attend, such as a speakerphone available at the agency's official meeting location, so the public can hear the discussion. In contrast, since an email exchange amongst the quorum of the members of a governing body is not open to the public, such an exchange in which an action is taken is a meeting that would violate the OPMA. And remember, action is broadly defined. It is very difficult to envision a way in which those email exchanges comply with public notice or attendance requirements for a regular or special meeting. One of the 2022 changes to the OPMA is a requirement that public agencies receive public comment at or before every regular meeting at which final action is taken. The 2022 amendments allow agencies to accept public comment either by written format or orally. If the governing body chooses written public comment, it can be submitted before or at the meeting. Any written comment received must be distributed to the governing body. The governing body may set reasonable deadline for submission prior to the meeting. The oral comment option is very similar to what many agencies were doing voluntarily before the 2022 amendments. Agencies can put reasonable procedures in place to allow for public comment. This may include limits to the time available for public comment or limit comment to those topics on the agenda. However, a governing body may also choose to accept public comment on any topic. If oral public comment is taken by the governing body, it shall, when feasible, provide an option for remote public comment for individuals that have difficulty attending. Difficulty attending may be due to a disability, limited mobility, or for any other reason that makes physical attendance difficult. A governing body is not required to accept public comment that renders orderly conduct of the meeting unfeasible. The OPMA has procedures for dealing with disruptions where orderly conduct of the meeting is unfeasible. The minutes of all regular and special meetings, except executive sessions of such boards, commissions, agencies, or authorities, shall be promptly recorded, and such records shall be open for public inspection. The OPMA does not require an audio or video recording of the meeting. Many agencies choose to do so. Public agencies are encouraged through the 2022 amendments to make audio or video recordings of meetings or to provide an online streaming option of all regular meetings of the governing body and to make any recordings that the agency does make available online for a minimum of 6 months. Violations of the OPMA can result in a lawsuit against an agency and its members. A court can impose a $500 civil penalty as personal liability against each member who knowingly violates the OPMA and a $1,000 penalty for a subsequent knowing violation. A court can also declare any action taken at a meeting not held in compliance with the OPMA null and void. And a court will award costs and attorney's fees to a successful party seeking a remedy under the OPMA. To recap, this presentation covers the highlights of the OPMA. Public agencies may be subject to other laws governing other particular meetings, hearings, procedures. Some agencies have particular laws that govern their meetings as well. Like the OPMA, the laws concerning agency meetings and hearings can also be amended from time to time. Therefore, agencies are cautioned to be mindful of all current laws concerning their meeting and hearing procedures. Thank you for watching the Attorney General's OPMA training. For more information, there are available resources for agencies to receive training and technical assistance for compliance with the Open Public Meetings Act. An official should first consult with his agency's counsel for routine assistance and training. Additional resources are listed on this website. The Assistant Attorney General for Open Government is also available to provide information about the Open Public Meetings Act.
A lot of information.
Yes.
What questions do you have?
I've got one. When it about request of public records, how long is a government entity required to maintain these records?
It depends on the record. So the Attorney General's office has this huge book of they're called DAN numbers. I don't know what DAN stands for, but all these different numbers. And they establish different timelines for different records.
Okay.
For example, some things that might be 6 years and then you can destroy the record. A lot of planning related items are basically kept in perpetuity until something changes, basically for the life of the project. So for like a new land use, if a new use goes on this property, the city has to retain all of those records as long as that property is used for that purpose. If something else comes in, don't need to keep all that old stuff, we need to keep the new stuff for the new use.
Because you just hear, stories about all these people, requesting records that are just unreasonable, just so they can make some money off the judgments, that kind of thing. So somebody walking here with something from 1957, it's not gonna work.
Well, that's the other thing, is it's also up to the agency to follow those timelines.
Right.
So if you have that document from the 50s.
Yeah.
And they request it, then you still have to produce it.
That's crazy, isn't it?
Yeah. it would be up to the public records officer and the staff to go through
Okay,
and
I'm just curious,
give,
yeah.
you know, either destroy or transfer those records to the state archives,
Mhm.
depending on the type of record.
Well, thank you.
Well, I think one of the most important elements too is you don't have to create records. Because
Yes,
occasionally you get people that come in and say, you know, sort of like want me to give a quick report of like, give me this, you know, this, this. You know, unless you have it, you don't
Yeah.
have to necessarily create it.
yeah, give me a list of all the meetings that when the planning commission discussed this topic.
Right.
Well,
Yeah,
you have to create a record to come up with that list.
yeah, so I mean, those are some of the important things. You know, I think with this group, and I think the other thing to recognize too, like you are a conduit of the city, so this is something I've learned over the years, even as a journalist, like if I ask you, or I ask, you know, I say, hey, Joseph, yeah, I need this, you know, and we have it, it is a public records request, you know, somebody. So even an oral request can be something that you have to follow up on.
Yeah,
So, I mean, that can get tricky. I mean, the sticky wickets is like, prove it, you know, I mean, that's the tough part, but. So, I mean, that's just something to be aware of. It's a legitimate request and somebody really wants to make it and. They come up to, oh, Mike, you know, I want to, they could theoretically, you know, if it's.
you
within
didn't
reason.
respond in 5 days.
Yeah, you know, so I mean, it is real.
Do we get cases like that people request public record?
Yeah, I mean, people,
Oh my gosh,
and just the volume of records requests that we get.
not as much for planning commission, but council and,
Mhm.
you know, general record. They all offer.
I got a question. Who's the public records officer for our agency?
Becky would be the official one. Her assistant's not working, so they're working on the process good. But so she had an assistant, and the police our police officers will process their own, so there's not. And then municipal court, I believe they'll do their own too, so you know, we'll handle it and stuff. Primarily, and then some of you know, obviously the police stuff they can handle themselves. Because we can't necessarily get into their records.
And, you know, generally, if there was anything that came in for the planning commission item, you know, that would be, you know, done through city staff and they might reach out for specifics, but it wouldn't be normal for, you know, someone to request records directly from you, you know, so I don't think that's something you need to be concerned with. It would come from the city officially.
People just go to the website, the city website, and there's a form to fill out. And then you send that to Jackie. So. That's. How you do it.
Open public meetings, any questions on that? You know, you guys hold a lot of study sessions where different topics are discussed and then you take formal action in the form of making recommendations on things like text amendments. Comp plan amendments and then project specific things like a new subdivision, annexation, site specific rezone. Questions on those topics? Probably the, you know, only thing I can think of where these issues have come up in the past in my previous work experience. You know, if there's a hearing coming up and we already know that it's contentious, you know, if someone stopped you at the grocery store or whatever. Wanted to speak to you about it. The best response would be, hey, we've got a public hearing coming up, you know, you can either submit comments in writing or attend the hearing to voice your comments. That way it doesn't become an issue of, you know, I talked to Ignacio at the store and he's privy to all this information that the rest of the commission isn't. That's kind of, you know, one of the main reasons why it's important to have all that information done at the public meeting or in writing, so then you all are getting the same information at the same time and are able to use that as part of your decision making. That way it's a fair and open process for you and from the public standpoint as well.
Have you witnessed or heard of a situation where public records were destroyed? and someone was fined for that, or,
I'm sure it's happened. I'm not aware of any,
You know.
specific instances from my past work. I'm sure it's
Yeah,
happened.
I've heard some people in jurisdictions destroying it. Yeah, I mean, there is a fine involved. I know the city of Seattle, they didn't keep records of text messages, so they got into some trouble about that, so. And that's something. One of the expectations to have records of it and they disappear. And I think in that case, some of them were actually deleted. I think it had to do with during COVID. Remember there was all the ruckus going on downtown and all the fires. So apparently a lot of stuff was deleted, not retained, so a lot of people got in trouble, so. You can't just blanket like, I mean, you could. I mean, I've heard people and colleagues, government that I've worked for, so that's the price of doing business, but that is not, how I would want to operate here, obviously. I believe in transparency, and I always tell people, look, if you don't want something to appear in the paper, do not text it, do not email.
Yeah.
Because I think another thing to recognize is even your personal Gmail, if you're conducting business on that's still on, that's on the record. They can request it, you have to provide it, so. And if you don't provide it, it's at your own peril, obviously, if they find out. I guess you could delete it, but again, as they said in there, you delete stuff and no one will delete it, that's from $5,000.
Yeah.
So yeah, it's.
Delete doesn't necessarily mean delete.
Yeah,
People can
and-
still find it.
In this day and age, deleting isn't like, I mean, there's still a trail of it, it's
Yeah.
might as well just, give yourself up. Yeah,
Stay out of trouble.
just don't be shady, do the right thing and you'll be fine, so, I mean, that's really the key. And, again, just be careful just be cognizant of everything you do as a representative of the city, it's in the public domain. I've sent some emails that I'm like, I take that back. So,
let's see, did we have anyone? I saw someone on the chat and then I saw two participants, but I don't know if that was
I
you
think
and
it's
Jackie.
just. Yeah, I think it's just
you and
us.
Jackie, okay, alright.
Question then, so on that same subject, so if you were to open a city email on your personal phone, does that start to you? Just to,
Well, the so, because everyone has a planning commission city email, right?
I do not.
You don't.
I'm getting that fixed, so.
Yeah, I mean, it might be a better question for Jackie, but I don't believe that. It really matters where it's open necessarily, because if it's a city email, the city IT can find where it's at. And so, it's really a function of the specific record, not so much where or how it was open. So. It wouldn't like open up the rest of your phone to records, 'cause
yeah.
it would just be the one, we want that email pertaining to the planning commission agenda, right, here it is.
Yeah, so it's not gonna matter the device you open, it's just more. What they're specifically looking for. Spring County Administrator used to have this guy, every month he would just go, I want all of Mike's emails. So it was just, so that they have that type of access.
Yeah, he passed away now, didn't he?
Well, there was the one gentleman, yeah, Robert, God, what's his name? Roger Link, yes.
Yep.
Yeah, he was pretty notorious for record requests. I remember when I first got to Franklin PD, he called me and said, oh, Roger Link, you're gonna get to know me. I'm like, oh, okay. So like, who's this guy, Roger? But I mean, you have individuals like that they just do it for fun and sport and they make money off of it. We had a little jurisdiction in Franklin County. They got bankrupted by master public records requester. I think she cost them almost $300,000 to $400,000 in fines. And it literally bankrupted them. So, I mean, you have individuals like that just do it for fun and sport and they make money off of it. We had a little jurisdiction in Franklin County. They bankrupted by master public records requester. I think she cost them almost $300,000 to $400,000 in fines. And it literally bankrupted them.
the city has, I think, 5 days to respond to a records request. And if they don't respond, they get fined, is that right? So-
Yeah, I mean, you'll get fines, so that's, I think it's important to recognize, like, if you get a records request on your email, don't just blow it off. You send it to either myself or Jackie right away and just say, hey, I got this from somebody, get it off your hands. And, because you guys aren't expected to search for the records and, and just because you have that document, let's say, although it fulfills it, we like to know, like, hey, we fulfilled it because we documented just in case illegalities, so. Let's say if somebody contacts Ignacio and you have it in your email. You bang it over, but just let us know, just like this guy made a request, so then we can document, make sure he doesn't come back on us and say, no one ever did it to me. Although we would be able to track that, but nonetheless, we like to document.
What if I was on vacation and then the 5 days expired and I didn't open my email?
Okay, think about
I
that.
think it's a little bit different when for the planning commissioners like us, because they have to go through the city portal.
Yeah.
So they have to submit it through let's say if it's written or emailed or submitted through online, then it has to go through Jack in this case.
Right, but I think legally, and this is a good question for Ben. My understanding is that just because we have these portals and all this and that, a guy can come along and say, write it on a rock and give it to somebody that's within our organization and say, here's my records request. Make sure that happens, so that, and that's what I used to think too, like, you gotta go through the portal, because there are some people that within various city governments will be like, there's an official process.
Yeah.
There ain't no process for real. The process is I hand you a piece of paper. I mean, I've had people come in and to Franklin County, where I was the records officer, and they would, here's my records request, and hand it to me like on a typed sheet of paper. And you're like, okay, how would you like this? What type of form? So yeah, so that's a little bit, like, I used to think that too, Steve, like, because I think we're so used to having a formalized process of, it's gotta go through this portal. But not necessarily, so that's why I say, like, I think it's really, you still might get in trouble, and that's a really good question. Because if a request lies dormant, it's almost, in my mind, it's like committing a crime. You're ignorant of the crime, you still committed the crime. So
I think the best thing, if we do have someone requesting public records, to tell them, hey, the right way, or not the right way, but the more adequate way is to reach out to the city of Sunnyside and request it from one of the other officials. We're just members and we're not part of the actual.
yeah, that's a good modus operandi. I mean, I think it would be definitely better to encourage them to contact the records person. Because you guys aren't, I mean, I would prefer you guys do that. But if they refuse and they say, no, Steve, here it is, man, then obviously you go, okay, you hand it off. It just, most reasonable people will do it the right way, or the way that's preferred. But as we know, you're always gonna have that one person that they just wanna go out of process and bust jobs and.
They might want to do a lawsuit.
Well, yeah, and then they go, I gave it to Steve, and who knows how they document it.
Like, who's Steve?
Yeah.
He only comes once a month.
They could single you out and just email it to you,
Yeah,
right,
yeah,
and
no.
expect the 5 day count to end up.
Exactly, so that's something I'm gonna check with Ben on that. Because that's a really good question, because just because it lies dormant in a planning commission member's inbox, is that the same thing as going into our portal? And is there I don't know if there's like a reasonableness standard, where it's like, it's not really reasonable to contact the janitor and expect a response, so that's.
I think the likelihood's just, I mean, it needs to be very specific, like
Yeah,
just a request for general information isn't a records request,
Right,
it's just a question, but if they're,
yeah,
I want, this email from this day or whatever, that would be something to get forward.
I think the one thing that to be aware of is a rolling quorum, so do you want to explain that to us, Joseph?
Yeah, so rolling quorum would be typically done in like email chain, if email comes in and. You have to have four for a quorum, right? So there's only three that are discussing it via email, but the three come to some kind of consensus and then. Add one, drop one off and add another, and then you kind of created a quorum by virtue of an ongoing discussion. And so, that wouldn't meet the OPMA. The best rule of thumb would be to just not discuss anything over email, that's just, or direct an individual email just to staff, and then you can follow up.
What about an email CC with 4 people in it?
That's.
That would, well, I mean, it's also kind of a function of, obviously. When we were setting up, the special meeting last month, trying to find time that works for everyone, I mean, yes, that's still a record, but that's not. Really an action that's being taken, that's a scheduling thing that staff is trying to.
Yeah, and
to
I'm pretty sure they
accomplish.
give you exceptions for that.
Yeah.
What I try to do is blind copy if I go to all the commissioners or city council people. And another technique is like, do not answer, or just, this is not for, I mean, I've seen that done. But I think the safest way is blind copying like the group, and then that way you guys can't answer collectively.
Mhm.
And,
No reply all.
yeah, exactly. Or you just say, hey, this is just for consumption, but that would, can't stop somebody from answering. But then you don't have to answer either, it's just kind of using sense out. But it's just try to overlook that, as long as you guys are in a forum, you could discuss things. But still, that doesn't allow you to get like a group of 3 and then 2 and 1, and then
Hey, I talked to
3.
so and so and so.
I go 3, 3, 1, and that's still. And again, it's just kind of using your head. Are we making decisions based on what we're saying? So I mean, you can see people, so they'll try to influence you. Thanks for the information.
Sure, it's a shop out of town, you want to.
Yeah. That is a Sunnyside technique. For.
Okay, so we don't have any public comments for 1 year, items from staff, Mike, do you have anything for us?
No, just appreciate you guys being a part of this, and this is kind of yeoman's work, not very exciting, but obviously, excuse me, a huge part of what we do, and just being careful and transparent. So definitely believe in that part of the process. Truly appreciate you guys being a part of the planning commission. It's an important part of what we do. And you guys are volunteering, so thanks.
Well, thanks for coming to the meeting.
Yeah, it's my pleasure. I'm glad. Well, and one other thing I wanted to, which you probably know by now, maybe, is we've hired a economic development director. So Derek Bratton out of Franklin County. So he worked for me when I was administrator. So he's wanting to get back into city government to economic development planning. So pretty excited about him coming on. So yeah, so he'll be here October 1st, and I'm excited to make that announcement soon. So he'll obviously be the one that takes over in October, and I'll probably come maybe to the next, but I'll come to as many as I can. But he's great. He's used to planning conditions and the process. So I think it'll be really helpful.
That leadership will be great.
Yeah.
Also, with the city being in a little bit of turmoil right now, everyone's gonna be watching everything, especially now. So, I guess just, follow the rules and ask a lot of questions, and, let's do our homework, when it comes to looking at zoning and annexing, let's really think about how that's gonna affect the city. With our comprehensive plan coming up, we have a lot to work on. So we'll be under watch probably more than usual.
And that's something, that we know this group and I already talked to Derek about, I know my desire talking with the port, really to come up with like a housing action plan of some sort. That's one of the things that Sunnyside, we don't have to sound out as residential. So looking at our comprehensive plan and seeing where we can rezone, upzone. See where we can change some of the boundaries. I think this is gonna be a huge couple of years for that. You know, this group could really be an integral part of changing the face of Sunnyside. Because talking with Jay, I mean, he really believes housing is gonna be the key to economic development for our region or for our city. And because he's facing the challenge of like, people, the first thing that company asks is like, what houses do you have? And what kind of variety of stock? And we just don't have a ton of it here, as you guys know, so that's gonna be one of my priorities as city manager. And obviously, this group's gonna be a huge part of that, so I'm kind of excited to get Derek in the door and then get to working with the port, working with this group, working with HLA. And just, you know, really working on this comprehensive plan, because it'll reshape Sunnyside. You know, so we do have a lot of work ahead.
Yeah, on the comp plan, so you know, we're in the first year of the grant. And the first couple tasks are developing a work plan and developing a public participation plan. But then the kind of the latter half of the year one tasks are looking at housing and population projections and a land capacity analysis. So that'll be, you know, a pretty big chunk of later this year and then into next year as accomplishing those tasks. Part of the housing projections is looking at this tool that the state put together called the Housing and Planning Tool. And basically it looks at population allocations, housing allocations by the county and then delegated out to the cities. And the new rules require the cities to identify areas for all economic segments for housing. So that'll be a big portion.
Yeah, we'll definitely hear more about that, so maybe you guys will be a big part of that.
Do we need to sign those certificates? Who signed? Would Mike, you sign that, don't you? We'll sign it, you sign it?
She said to sign up and then get it back.
Oh, okay.
I guess that is definitely.
Or Brandon. Put on your fridge.
Britt, did you excuse Tom this meeting? This is Jackie, sorry.
Yes, I'll excuse, he's in California with his grandkids.
Okay, I'll note that it was without objection then.
So next meeting, oh, we don't have one.
That would be the second Tuesday of October. And we,
The 8th.
yeah, we probably need to find out from the director what time works for him. In the past, we've done it at 6:30, we changed it to 5:30 just because it was easier to
Yeah, I'm
stay
sure.
after work than it
Yeah,
was to
sure.
go home and come back.
Find out.
So we can let Jackie let us know what that'll be once we talk to the new director.
Yeah, so, yeah, so we'll sometime in early October, we're thinking.
Let us know.
Okay, sounds good.
6:57 during the meeting. Thanks,
Awesome.
everybody.
Thanks,
Thank
guys.
you.
Well, thank you for your time.
Thanks, Joseph.
Yeah.
Yeah, so just keep them moving. Keep them going.